Commission on Ethics and Public Trust meeting. Today is August 13th. My name is Nelson Belito. I'm the chairman of the Commission on Ethics. And we're going to go ahead and start off with the first item on our agenda this morning, which is the approval of the minutes. Fellow commissioners had an opportunity to read this.
Yes.
Do I have a motion?
I move to approve the minutes. Moved.
Second.
Second.
We have a motion, we have a second. All in favor?
Aye.
Opposed? Hearing none, minutes are approved. Our second order of business this morning is public comments. Speakers are limited to 3 minutes. Do you have anyone from the public that wishes to speak this morning? First.
Good morning, Mr. Chairman, members of the committee. It's Al Cresto once again.
Good morning, sir.
And once again, I appear before you, Mr. Chairman, and ask you where that letter is that you promised to write me back in March. We're now into August. So if I can assist you by buying you a pen or a pencil and some paper, I'll be glad to provide that to help you comply with the promise that you made me. I also want to address an opinion here issued by the Council 14165, which is going to come before you today. It's a request. Is it here? I got it and then I lost it. It's a request by the Miami City Attorney about commissioners being prohibited or not prohibited from visiting community centers, elderly centers, or other venues with the purpose of educating the public on ballot questions and answering constituent issues, providing the public funds are not used to further such efforts. Does that include the public funds that are used to transport these individuals? Because all these people, you know, none of them like to drive themselves. They've all got attached to having Sergeant of Arms drive them around in SUVs, subject that I raised before this board several years ago. So the cost of the Sergeant of Arms is a public cost. The cost of the SUV and the maintenance of that vehicle is a public cost.
170.
So
170. Inquiry.
170.
Yeah,
So I'm just raising this for you all to consider and discuss if you wish. Because it's and then of course you're aware that these public officials, when they do this, turn around and get reimbursed in the form of campaign contributions by the people who are benefiting from them going out as proxies to speak to the community about these ballot issues. So, and I specifically refer to one of the ballot issues on, well actually several ballot issues on the agenda this time. One is over the submerged lands, which affects developers on Biscayne Bay and Brickell, and the other is the now infamous skyrise, which the developer wants to call the Eiffel Tower of Miami, and which I and others have called names which I shall not reference here. Thank you.
Thank you, sir. Any other members of the public who wish to speak? Very well. Hearing none, we will move on to our third item on the agenda, which is the request for opinions. Ms. Ramos.
Good morning, everyone. Request for opinion 1403 is included in the main packet. The issue in this case is whether service in the Reserve United States Armed Forces constitutes outside employment, both for purposes of requesting permission and also of disclosing the income at the end. We started to look at this question when I began to draft the memo on outside employment, and we came to the conclusion that the answer should be no. The background on this is as follows. We've had several staff opinions throughout the years, but they have at times been conflicting. We do not have an RQO on point, and that's why it is before you today. If you look at our precedent, back in 2001, there was a staff opinion that said that a request for outside employment should in fact be submitted when engaged in military activity. Then in 2003, we said it should not be considered outside employment. We said that again in 2008. And then in June of 2008, there was a memorandum put together by the former general counsel, and there she said it should be considered outside employment. Yet in 2010, our former executive director opined that it should not be consistent with the 03 and 08 opinion, and that neither of the two requirements are necessary. I did some background research. I looked at all the policies in the county's leave manual that discuss military service. I also looked at the Florida Attorney General opinions, at the state of Florida policy regarding military service, as well as the federal policy. And it is clear that none of them treat military service as outside employment. And so for that reason, we believe that the appropriate opinion is that active military service, since it cannot be denied, should not be considered outside employment. Request for permission is not necessary. And disclosure of the outside employment income is not necessary. Now there is one caveat. If the individual is a reporting individual, financial disclosure reporting individual, under the statute, then he or she should disclose that income at the end of the year.
Any questions?
I need a motion to approve.
Go ahead. Motion to approve.
Second.
Motion and a second. All in favor?
Aye.
Any opposed? Hearing none, the request for opinion passes. Thank you, Ms. Ramos. Our next order of business is item number 4, Section 8, Ms. Diaz-Greco.
Good morning, Commissioners. I think that's better. I start this morning with, as we usually do, with a summary of Section 8 requests with a little bit of a variance, which is to distinguish these requests which are made by county employees that are seeking, in fact, to contract with the county to become Section 8 landlords. And they would be under the restrictions in the ethics code that are under C. And we are going to compare this with a new series of inquiries that we have developed in working with the housing, which are under an exemption in the C section of the code, C55, which does permit county employees to seek housing assistance under certain circumstances. So for these purposes, we'll start with the Section 8, and we will discuss the subsequent ones when we talk about the inquiry summaries. So with respect to the Section 8 landlord, these employees are under the jurisdiction of the Commission, and they are seeking to contract with the Housing Department to become Section 8 landlords under that federally funded program for low-income tenants. We go through a compliance procedure, which we have shown the Commission before, and as we go through this compliance procedure and we can document that these employees do not work for the Public Housing Department and therefore would not be able to place themselves in a position of conflict with respect to becoming Section 8 landlords, we therefore recommend approval of them since none of these employees work for public housing.
Very well. Do I have a motion? We have a motion to approve. Do I have a second?
Second.
I have a motion and a second. All in favor?
Aye.
Any opposed? Hearing none, motion passes. The approval is granted.
The next item, if I am correct, is going to be the summary of inquiries.
We're on item number 5 for those in the audience.
I ask the commissioners to observe that going forward, in order to track these public housing INQs, which are proceeding under a separate compliance procedure, which I'm going to discuss shortly, there will be both of these included now in the inquiry section. The first section is going to be the traditional summary of inquiries, and this month there are a couple that I would like to go over the commission. One is 14-168. I also don't know if our executive director, who also authors these, would be interested in discussing any of these or highlighting some of these to the commission. But in 14-168, again, outside employment is always a big issue. In this particular case, there is an employee that works in the accounting section of public housing and also is engaged in outside employment as performing accounting services for her church, the church in which she is a member. And that church was seeking to enter into an agreement with a non-for-profit low-income housing developer called Carrefour. This organization, Carrefour, was established originally by the Chamber of Commerce quite a few years ago. And so Carrefour sought to enter into a contract with the church to develop low-income housing in that property, and part of the funding for that low income would be funding that would be sought from public housing. And given that she is also a public housing employee, a letter of opinion was sought on this matter, and looking at precedent that was established before, this employee does not in any way, shape, or form work in the department that would administer or make any decisions about the type of grant that the low-income housing developer was seeking. And it wasn't her employer directly who was seeking assistance, it was someone they sought to enter into an agreement with. Following the precedent of the commission, the opinion was that there was no conflict, but that of course she should be very careful to ensure that she in no way was involved in this agreement, either in her employment as a public housing employee or in her outside employment, keeping books, etc. for the church. That I thought was one that the commissioners might find interesting. Another one that I would point out would be 14-171. We have always a lot of issues with under which circumstances employees may attend seminars or receive payment to attend seminars or training. And in this particular case, in 14-179, there was a registration valued at $1,695, which the county vendor was going to waive based on a points program that they have for their customers. If you make referrals or under certain circumstances, if you do several things, they would give the client points. And the county had earned enough points, as it were, to obtain a registration valued at $1,695. However, based again on previous commission precedent, we opined that this gift would be prohibited. This vendor customer points program would not be a program that would be permitted in a public sector type of situation, although it might be permitted in the private sector. So again, in that case, it was denied. It was considered an improper gift. And obviously the only way that this can be waived is by a 2/3 majority of the Board of County Commissioners. If there are no other questions on the summary of inquiries, I would like to pass on to the new housing inquiries.
Are there any questions? Again, these are informal. These are opinions that have already been granted and approved by the executive director, so we do not need to take a vote on these. You may proceed. Here are any questions.
Commissioners, I have placed next to your seats this packet that says Public Housing and Community Development Department. Generally, the code, if I may, generally the code has certain restrictions on employees and relatives of county employees as well as public officials on conducting business with the county. This is particularly the case in a prohibition on doing business with your own department, or if you are a board member, for example, on doing business with your own board, or in any way being responsible for administering any contract that you would be involved in, for obvious reasons, because you would be able to obtain perhaps a benefit higher than that than the general public would be able to obtain. However, under C55, that would be under C and D, under C55 there's an exemption that basically says that county employees and their relatives and pretty much everyone in B, everyone that's covered by the code, may receive and apply for assistance from public housing to participate in county, state, and federal housing programs if they are otherwise qualified to do that. However, in C55, it indicates that the person that is applying for this assistance cannot work in the section or in the department that provides this assistance. Because of the training that we did, particularly last fall, we were approached by the housing department. And we had received these requests for opinion infrequently, and actually had wondered over the years why we received these requests for opinion so infrequently. It turns out that there really was no formal procedure in place at the housing department to identify county employees or public officials that would therefore be required to ask for a letter of opinion from the commission. So we have been working with them over several months to put this process in place. We created a three-step process. Number one, you will see this first sheet. We worked with a housing department, to create this sheet, which is attached to absolutely every application for every housing program. And in this sheet, we can now identify if it is a county employee or a public official that is going to be required to seek a letter of opinion. From there, we developed an application. If a person does indicate that either they or a close family relative is a county employee or a public official, then they must complete this request for an ethics opinion, which is the second document that you see. Notice that we have created this to identify the county employee or the immediate family member. Most importantly, on the second page, you will see a list of all of the different types of assistance that they can apply for. This is particularly important because we were advised that advertently or inadvertently, there were some employees in public housing that were working in the department from which these programs are administered. So we have been working with them for a couple of months now, working with their human resources department in order to identify what particular aid these employees or their immediate family members are receiving, and to ensure through the human resource process that they are not working in the department from which they would be receiving assistance. And after that, we have prepared and researched the compliance letter, which again becomes part of the employee's HR file that indicates the specific loan that they are applying for, which triggers HR to make a notation in the system that that employee can never be placed in that department. We were advised that what occurred is that perhaps at the beginning of a loan, which might be 15 years, an employee did not have a conflict, but over a 5 or 6 year period might end up working in the housing department in that particular department that administered the program. So we've been working with HR and public housing. They have 400 employees at public housing, so you can imagine that this has been a really big project. And the last document that I will point out to you is that, of course, in addition to this, there has to be extensive training. We have been working and are working with the department in HR. They will be having training next week for the majority of the public housing employees, where we will be reviewing this process and giving training on this issue. It's a long-term process. Compliance is not particularly glamorous, but when one reads a lot of the literature on this issue, it does tend to be very effective in prohibiting conflict of interest and in creating an environment in the public sector that is freer of conflicts of interest. If the commissioners have no questions on this process, you will see that we have summarized the county employees that sought assistance and what type of assistance they sought. And we went through the compliance process and ensured that they were not working in a department that administers that particular program. And so following what is set out in C55, we either approve or disapprove.
Approved everything.
In this particular case, everyone was working in a department separate from the public housing department.
Any questions from the other commissioners? Hearing none, we'll move on to item number 6, Miami Beach Lobbyist Appeals. Ms. Ramos.
So we only have one this month. For the benefit of the newer commissioners, I'm not sure if we've had one of these before you, so I'll give you just a quick background. The City of Miami Beach requires lobbyists to file an expenditure statement the year after the year in which they were registered to lobby, detailing any expenses that they had in furtherance of that particular effort. When those statements are not filed, a series of letters go out by the clerk's office. They do not receive compliance, they come to us, we try to reach out, but there's a fine of $50 per day. And given that that can be quite onerous, there is an appeals process in place. And so they come to us, they appeal to us, they explain to us the circumstances that led to them filing late, and then we can either reduce or waive the fine that's pending against them. In this particular case, you'll see 1341, it's the 41st that we've done this year. Mr. Riley worked at a particular law firm, he moved to another law firm, and he was under the impression that the previous law firm was going to handle all of the filings. In fact, out of I think 10 clients, 9 of them were handled by the previous firm. This one fell through the cracks. He did not receive the notices. He was assessed a fine of $8,400, obviously, because it's been several months at $50 a day. He has no history of late filing and 0 expenditures, so I'm recommending a waiver in his case. You should know that I always check if they have previously received a waiver. I will not recommend a waiver again, simply a reduction of the fine.
We have a motion.
Years, not a couple of months.
I'm sorry, I can't hear.
Move to approve.
Thank you.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Hearing none, the motion passes. Mr. Riley will not be fined in this matter.
Question, actually.
Ms. Ramos?
Of course. What percentage of these appeals tend to be granted? Just ballpark. I'm just curious.
Honestly, the majority. Because most people are not aware of the requirement. And what happens in 9 out of 10 cases is that people have 0 expenditures. So we had the same requirement at the county a few years ago. We were able to get the legislation changed so that if you have 0 expenditures, you don't need to file. Because we would chase these people just to get a document that's at 0. Miami Beach still has a requirement for all filers. And so, that's where.
Thank you.
Thank you, Ms. Ramos. Our next order of business is the Executive Director, Mr. Sinclair.
Good morning, Commissioners. The first matter, you all should have a copy of a community outreach report from Mr. Robert Thompson, who I'll ask to come forward. About once a year, in the last couple of years, I have asked Mr. Thompson to prepare for the Commission a report on the various outreach programs that we have, listing all of the sessions we do, as well as highlighting some of them, with the idea that the Commission is well aware of the enforcement side of this agency, because that happens at meetings, as well as the opinions that we provide, but the outreach portion, the training portion, which is a very important part of this agency, which is a substantial commitment is made by this agency to community outreach and training. That's not something you see much of. And Mr. Thompson, who is our outreach coordinator, and who I've sometimes referred to as the deputy mayor of the county, because he is probably more recognizable than anybody else in this agency. He interacts with more employees and through the training programs we have than anyone else does. Although certainly other people in the agency are involved and actively in our training programs. But Mr. Thompson is kind of a constant. He's the guy who sets most of them up, who does more than anyone else, and who often has to assist me in the technological aspects of his presentation. So I asked him to come forward. You don't see him often here, but at least once a year I try to get him here to give a presentation on our outreach events and programs for the information of the commission. So I'll let Mr. Thompson.
Good morning, in the audience. I put together 2 documents. I am not going to take you through the presentations, one, because we'll be here until, sometime this evening. But what I've done is put together the community outreach, and it's a small briefing that talks about who we are, what we do, very simply put, some of our major events, the campaign ethics conference, and the 2013 Ethical Governance Day. For those of you who didn't get a chance to attend, I can tell you that over 150 attendees were part of the Political Campaign Ethics Conference. It was well attended. And normally when you have sessions from 4 to 5 p.m. at the end of the day, most people are gone. I can tell you that the room was filled and we had a full house and so on and so forth. And for attorneys, they were happy because they were able to get 8 CLE credits from our organization. One thing that you don't see is we started this in May. It was the Miami Beach Regulatory Training. We started this in May of 2013 and we finished in 2013. But we did 8 sessions for all of the regulatory employees, everything from introduction to ethics, penalties and consequences, law of bribery, application of legal provisions, local enforcement, issues, train the trainer, and last but not least, we concluded with one-on-one interviews with all those City of Miami Beach employees. Ethical Governance Day is always fun. We're moving the 3rd year, but 2013 we were able to put 284 volunteers. They were placed in the 60 classrooms throughout all of Miami-Dade County. And the bottom line was to discuss civic engagement and making their communities better communities. When we talk about outreach events, I just took some of those events from the actual presentations document. As a minimum, there's a requirement for all elected officials to take ethics training, and it's mandatory. We conducted 17 sessions to include those for the Board of County Commissioners and municipalities within Miami-Dade County. Lobbyists training, there are people who will say we never have enough of it, but we did 25 sessions and it impacts not only county lobbyists, but those City of Miami lobbyists as well. In terms of attorneys' luncheons, they are very important to our organization as we reach out and make sure that the other attorneys know what we do and vice versa. And campaign skills seminars are usually asked for in most cities after somebody gets in trouble for some reason. We continue to provide training to county and municipal elected officials, department directors, staff, employees, and for those of you who did not know, the county has 97 active advisory boards that we provide training to. The lobbyist training I talked about briefly, these are the topics that are covered, so I won't dwell on that. I mentioned the attorneys' luncheons and the speakers and the different types of subject matter that are discussed. And again, I talked about campaign skills seminars, who, what, where, and how. And you'll find that we make it our business to get out into the community. What you don't see a lot of is advisory boards, whether it's here at the county or at the location of the organization. Mr. Sibilia and myself, we go out to those various organizations. But the one thing I always want to make sure that you clearly understand is that the organization works as a team. I may be the outreach coordinator, but without the folks in the office, we wouldn't get it done. And I can tell you, as we move forward, we are getting more and more requests for training, and we get it done. So unless you have any questions, you can tell by my voice I'm feeling very well. My intent was to be brief, and I'm hoping it is brief. Any questions, comments, anyone have anything to say?
I have a question, sorry to make you talk. How big is the staff?
Well, for training purposes, I say 14, but most of the time it's myself, Mr. Senorino, and depending on the type of training or the session, I try to make sure it gets covered.
Me, Miriam.
Yeah, that's what I'm saying, the staff.
All the attorneys
we get
involved,
it, we get it done.
And Ms. Sibilia generally.
We do it with 14 people. Okay.
Mr. Thompson, thank you. I will not make you speak anymore, but I do want to congratulate you and your fellow staff members here for making that.
Okay, thank you very
and
much.
educate the public and officials. Thank you very much.
Thank you.
Thanks.
The next matter I wanted to bring up briefly is, as I indicated at the last meeting, we've scheduled Ethical Governance Day 2014 for now finally for October 29th, 2014. The date was kind of up in the air until the schools were able to work their schedule out so that they could accommodate us on that day. There is in your packet a resolution that we have passed each year and that I will ask the Commission to vote on and pass, basically endorsing and proclaiming Ethical Governance Day. We also have had, the school board has already acted on it. I expect that the county commission will be acting on it also to join us in a partnership on Ethical Governance Day. You might also notice that in your packet there is a flyer that we utilize for speaker registration that we have on our website, but we also distribute it around the county. We were lucky once again this year to have Mr. Moran, Jim Moran at the Miami Herald provide us with a sketch that was utilized in that flyer, and we're hoping to better our record. Last year we had nearly 300 volunteers, and we're hoping to do at least as well this year. I would ask the Commission for a motion and vote on the Ethical Governance Day resolution.
Fellow commissioners have an opportunity to review the resolution.
Yes.
Do I have a motion?
Second.
First, we need a motion. Let's speak up.
Yeah.
Little English.
Voices to the-
I move to approve the resolution.
Thank you. Do I have a second?
Second.
All in favor?
Aye.
Any opposed? With that, the resolution passes. And let me just comment here, so the Ethical Governance Day will be on October 29th, 2014. It is a great opportunity to educate our youth in this community. Obviously, we have in our title the issue of the public trust. The part of gaining the public trust is educating the public, and I just think this is a fantastic opportunity for us to get out and have attorneys, public officials come out to these high schools and train these, educate these students. Even if they don't get it all, some of them get it, and that's certainly worthwhile. So again, I commend the Commission on Ethics for the work that they do in putting this together.
Mr. Chair,
Yes.
there are registration forms in the table back here if anybody in this room is interested in signing up.
Yes, and I encourage my commissioners to please to join us, as well as those members of the public, as Mr. Crespo runs to sign.
Rush to sign up. I volunteered last year and you didn't
That's
take
great.
my offer.
Not me personally, though.
Well, no, just.
Okay, very well. We'll move on to the next item, Mr. Sitzer.
Next item, Commissioners, at the last meeting, I included a copy of a pending proposed ordinance in the County Commission that would increase the period of time during which an ex-county employee, or actually would apply to municipal employees also, may lobby the government, the agency that they come from, the county. The current two-year rule provides that upon ceasing their service, there's a two-year period during which they may not lobby their former government employer. Now, the pending legislation would increase that from 2 years to 4 years. It went up for first reading before the County Commission in the past last month, and it passed, but just barely, 7-5 in favor of the ordinance. It will now go to a committee hearing and a public hearing. It will then come back presumably to the commission for a final vote on the legislation. Given the closeness of the vote, it's by no means a certainty that this will pass. I brought it before the commission because from time to time, when there are changes to the lobbying ordinance, we are often asked for our opinions and our input. And I'm certain that I will be asked, and I plan on being at the meeting of the commission when they take it up, as to, well, what does the the Ethics Commission feel about this particular legislation. So it's really up to the commission to take a position or not take a position as you may see fit. I will just, for what it's worth, although it's certainly not binding on the commission, give you my own input on this. I think it's a good piece of legislation. We have in our lobbyist training program we show a video of the disgraced and formerly imprisoned lobbyist Jack Abramoff doing a 60-minute interview in which he discusses the fact that when he was in his heyday of lobbying, he made it a practice to talk to congressional staffers about the fact that he would like to hire them someday when they finish their county, their government service. And he makes the comment that once he made that statement, he owned them. He owned them. All right. Now, increasing the period of time from 2 years to 4 years doesn't mean that they'll never come back. In fact, Mr. Abramoff suggested that they should be a lifetime ban on lobbying by former elected officials. Nonetheless, that's not what we're looking at here. The question of whether it should be increased from 2 years to 4 years, I can say that certainly it would diminish the perception that someone is trading on whatever chits or whatever influence they may have developed as a public servant in the private lobbying field. I think that extending it from 2 to 4 years makes it less likely that they're going to be lobbying people who they had interaction with or on matters that may still be alive from the time in which they were with the government. Recently, there was and I think this just goes to illustrate the issue. I'm not going to cast a dispersion on anyone, but a former deputy mayor recently retired. He was the county's lead person in the lobbying that went on regarding the soccer stadium. All right, and he's now left county employment and gone to work for a major lobbyist in the state. That also happens to represent Mr. Beckham and the group that was involved in the stadium issue. Now, that's not to say that he will be anyway involved in that again, but he could. It has the prospect within 2 years he could conceivably be lobbying the county on a matter that he was personally involved in. I think it's just and this legislation, by the way, wouldn't affect him, so he could still do that. But I think that it's a public trust issue, and I think this is one of those areas in which the public trust is affected by the perception that people use their contacts in the government from government service for some type of private benefit. The only argument that I've heard advanced against this is that it's longer than most other places. That most other places have a 1 or 2 year lobbying ban, which is true. I don't see that as a reason to take this extra step to promote the public trust. I see no reason why Miami-Dade County shouldn't be a leader in ethics or in any type of reform that might enhance the public trust. So I don't see that really as an argument to be against it. I see it as an opportunity for the county to take a step and to be a leader in this area and to have people say, Miami-Dade County has taken the lead on something and maybe other people will follow. So that's, for what it's worth, that's my own perspective, but I'll leave it up to the commission in terms of what, if any, action you may want to take in regard to the ordinance.
Any questions from my fellow commissioners?
I have a couple of questions. I might be saying that all day. You actually answered part of it. I was going to ask how this compares to comparable counties in terms of our size. So when you said it's longer than most, is that of all sizes of
I think so.
municipalities?
I would say so. I think 4 years is a long time in compared to most others that I'm aware of, sure.
Any other questions?
Do you know what the federal, I used to know this, what the federal rule is right now?
I don't think it's 4 years. It's less time.
4 years, okay.
My own personal opinion on this is that I think it's a good idea. I've always emphasized gaining the public's trust in our community, and I think it's something
I'm not big on, we don't need to go out there and try to send a message. Some things are just the right thing to do, and in my opinion, this is something that is the right thing to do. There could be the counter argument that you're limiting people from legitimate employment after they work for the county, but if you choose to be a public servant, you're beholden to the community, especially elected officials, and it's not a position for private gain. And being a lobbyist provides you certainly with that access if you were in a prior position. Again, I'm big on weighing the balances because I want to be fair, but my own personal opinion on this would be that this is something that we should support. I think it's overdue. Is 4 years too harsh? I personally don't think so. I think 2 years, I think we've seen here at the Commission on Ethics, is not enough. So for those reasons, I personally, again, I'm not the one to impose my view, but I certainly want to convey my own personal opinion on this, which is to support this, and I would encourage my fellow commissioners to do so as well. With that, any other comments or any other questions from the fellow commissioners? Is there any kind of motion that any of my fellow commissioners wish to make on this issue?
I have to have another question. I don't think this is a reason to vote against it, but I want to know if there was discussion or preferred discussion that this might deter some people to go into public service. I don't think that that's might not be the kind of person you want anyway in public service. And I know obviously kind of in the federal system, it's very common for, you know, SEC commissioner to go work at a major law firm 3 days after they leave, and though it's not technically lobbying, it's pretty much doing similar kinds of things, and that's very common. Again, I'm not saying that this is a reason to vote against it, but I just want to know if that discussion was had about any possible deterrence effect and what the counter arguments were.
And I followed this issue for a while. I have not heard that particular argument made. I would emphasize that this doesn't mean that somebody couldn't go to work for a lobbying firm or any other firm that might be doing business with the county. It simply means they cannot be involved in lobbying their former employer. As a lobbyist, they can still be employed. So it doesn't limit their employment completely at all. I mean, it just limits their employment from as lobbyists. So, and my own sense is that if somebody is motivated to go into public service for the reason that they will eventually become a well-paid lobbyist, I'm not sure that's the right motivation for public service.
I personally agree, and again, you're not limiting them from being a lobbyist at the state level, from lobbying the municipal, if they work for the county, as an example. If they work for a city, or municipality, you're not limiting them to go to the county and lobby the county. So, again, my personal feelings are those. Any additional comments or questions? Does anybody have a motion? No. Motion one way or the other. Does anybody have anything that they wish to
We're moving to approve it, or moving to
We would need
support
to
it?
make a recommendation if we wish to, or we could remain silent on the issue. There is an upcoming commission meeting, as I understand, and at that time it will be presented at the Commission on Ethics. If we support it, it will be conveyed. If we don't, it wouldn't be brought up. It's up to my fellow commissioners.
I was actually just bringing the verbiage. So I moved to support it, or whatever is the appropriate term that we're looking for.
Second.
Very well. Just so it's clear, in terms of supporting, we would be supporting the legislation here as written. Right. Commissioner? Is that what your
Yes.
motion is? And I
Yes.
do have a second. All in favor?
Aye.
Aye. Any opposed? Hearing none, our motion passes and our recommendation is to support the 4-year ban.
This will be effective when?
Well, it's coming up for final
Oh,
passage,
okay.
and it would be effective after that, obviously, if it passes. The final matter I wanted to just bring up, partly because the newer commissioners don't have any knowledge of this because it happened last February, but the Commission on Ethics adopted on staff recommendation, a resolution that the county adopt a honor code for its public officials and employees, the basis of which would require that they report any kind of serious ethical wrongdoing or certainly criminal wrongdoing that they may become aware of as in the course of their duties, and that there could be sanctions for not making that report. That matter needs to go to the county commission and needs to be implemented if it's going to actually take place. So I wanted to just inform the commission that there has been some activity on this, that I have had meetings with some of the commissioners individually. I've met with the county attorney's office on several occasions, and it was suggested, I think appropriately, that we needed to come up with some language that would further define maybe the types of activity that it would apply to, which we have done. And there is we're in the process of putting together an implementing order for the county commission to consider, along with a resolution. The commission chairperson, Rebecca Sosa, has agreed to sponsor this item for the county commission. So I would expect that this probably will be coming before the county commission sometime in the next month or two for action. And I think it's something that we can feel proud of for having initiated, and I just wanted to bring that to the attention of the commission, especially the newer commissioners, and I will be reporting back at a future meeting in terms of what action takes place.
So grossly unethical is going to be defined with some examples, because I'm looking at number one. That could be a matter of interpretation.
You're right, and I think that to giving them some guidance as to the types of activities that, in fact, the implementing order will specify certain statutes, and also we'll have a dollar threshold for the money involved in case the unethical activity involves some type of misuse of funds, that there at least be a minimum amount for it to fit into that category. That's all. No action is asked at this point. That's really purely an informational item, and that will conclude the executive director's report.
Thank you, Mr. Secretary. Our next order of business is item number 8, the complaints open session. We have the ratification letter of instruction from the procurement department.
Good morning, we just have the one, C-1342. I had presented a letter of instruction back in July, and Commissioner Bermudez, who unfortunately was unable to make it today, had requested that the director of the procurement department, Miriam Singer, appear to ensure that any discrepancy would be corrected. We, upon speaking to Ms. Singer, learned that this procurement was actually put out by the aviation department, which has its own procurement department. And Ms. Clark Vincent is the director of that department. I believe they're both here and ready to address any concerns and questions you may have. Because we learned that it was put out by aviation and not procurement, we amended the letter. It's in your packet, and it is now addressed to the aviation department. And unless you have any questions, fine.
Any questions from my fellow commissioners? Questions? Do I have a motion to approve this? I have a motion. Do I have a second? Motion is second. All in favor?
Aye.
Any opposed? Hearing none, motion passes.
Thank you. Both Ms. Singer and Ms. Clark Vincent are here if you'd like to hear from them.
I don't find that there's a need since we've approved it. Thank you for being here, ladies. The next order of business is a closed session.
So I have a question. This opinion that you issued, these inquiries, are they retroactive?
An inquiry is like a letter of opinion, but
Right.
it's based on precedent, so the staff has already sent them out to everybody.
No, I'm saying, but is it retroactive? In other words, could it apply to, oh, it can't, doesn't, in other words, they were able to do it in the past. Okay.
Session.